I've got a great question for you. Will bringing a lawsuit against your doctor for medical malpractice guarantee that he pay the consequences for his carelessness? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is no, it will not guarantee that your doctor will pay the consequences for his carelessness. Now, what's this all about? So let's say you believe that your doctor was careless and caused you significant harm and injury here in New York. And now you decide you want to bring a lawsuit against him. But before you do that, before you go ahead and try and file a lawsuit, first you've got to find an attorney who's willing to investigate your matter. Then you've got to get all of your medical records, or actually your attorney has to get them. And then he has to get those records reviewed by a medical expert. Only if a medical expert confirms that, number one, there was wrongdoing, and now that wrongdoing was a cause of your injury, and now your injuries are significant and or permanent, only then are you permitted to go forward with a lawsuit. Otherwise, if a medical expert does not confirm that you have a valid basis for a case, that's it. You can't even go forward. You can't even get into the courthouse door. So now you believe that your doctor was careless, and now you suffered all of these injuries because he violated the basic standards of medical care. And now you're thinking in your mind, okay, if I go ahead and sue him, I'm now going to either settle the case or go to trial, and I'm going to be victorious. You're going to win your case. And the jury will give you lots and lots of money as a form of compensation for all the harms and damages and losses that you incurred because of your doctor's carelessness. But let me go back to the title that I asked in this video. Does bringing a lawsuit guarantee that your doctor will suffer the consequences as a result of his wrongdoing? And as I mentioned, the answer is no. And you want to know why? It's because even if you have the best case in the world, even if you have all of your medical experts lined up who say the same thing, that yes, your doctor was careless, and yes, his carelessness caused you injury, just because you have a great case, and you have great experts, and you have great witnesses, and your testimony is terrific, guess what? It does not guarantee that you're going to win your case. Now, you might be asking yourself, how is that possible? How could you not win your case if you believe you have a terrific case, and if your medical experts believe you have a terrific case, and you've got the best attorney in New York? How could you not be successful in your case? Well, there are a lot of ways that you could not be successful. The first is that the jury doesn't believe you. If that's the case, in all likelihood, you're going to get thrown out without a dime. The jury may not believe your medical experts, no matter how good they are, no matter how good your attorney says they are. The jury may not believe your lawyer, or any one of those factors, or multiple factors, or all of those factors. Any one of those factors could contribute to the jury deciding, you know what, you are not entitled to a verdict in your favor. You have not shown us that you are slightly more likely right than wrong, that what you are claiming is true. And if that's the case, your case is over, and you get absolutely nothing. The jury could come back and decide, you know what, after all of this testimony, after all of these allegations, we believe that the doctor was not careless, that he did not violate the basic standards of medical care. In that instance, you go home without a dime. So what else could happen? Well, the jury might find that yes, your doctor in fact was careless, but his carelessness was not a cause of your injury. It doesn't have to be the cause, it only has to be a cause. And again, you might be saying, how is that possible? You've got all of your testimony, you've got all of the evidence pointing to the fact that your doctor screwed up. And as a result of his screw up, his carelessness, yes, you suffered these injuries. But the jury may not see it that way. The jury may decide, yes, we believe that the doctor screwed up, but that screw up was not what caused your injuries. If there is no link or bridge or connection between the doctor's carelessness and your injuries, guess what? The jury comes back and says, sorry, you get nothing. Time to go home without a dime. So that's another way that the jury could turn you out and tell you, listen, you are not entitled to a verdict in your favor. So here's another way that you could wind up losing your case, or actually I shouldn't say losing, but not getting the ideal outcome that you were hoping for. Your case has now reached trial, and now the jury has heard all the testimony and all the evidence. They are now in the jury room deliberating to decide whether or not you're entitled to a verdict in your favor. And you know what they find? They find, yes, your doctor was careless. And they also find that his carelessness was a cause of your injury. What does that mean for you? It means now they go on to answer the next series of questions which talk about how much money you are to receive, your damages for all the harms and losses and injuries that you suffered, the pain, the suffering that you endured from the time of the wrongdoing up until the time of trial, and then from the time of trial into the foreseeable future. And then they'll evaluate your lost expenses, your lost wages, and any other elements of damages that you're claiming. So here's another way that they could turn you out of court with a very little amount or zero, which is highly unlikely if they get to that point. So now they're deciding how much money you are to receive. Well, you're thinking in your mind, and your attorney is thinking in his mind, that yes, hopefully you're going to get millions and millions of dollars for the pain and suffering that you had in the past as well as into the future. And now your attorney makes a very compelling argument that yes, you are entitled to receive all of that money for each element of your damages. And now the jury comes back with their verdict, and you are shocked, you are stunned, you are out of your mind. Why? Because now the jury comes back and gives you this much money. You asked for this much, and they give you this much, a tiny, tiny fraction. And you're thinking to yourself, how is that possible? How could they possibly do that? Didn't they hear the testimony? Didn't they hear how badly injured you are? Didn't they understand all those activities you can no longer do? Didn't they hear the testimony from your experts who said, yes, you are permanently disabled. This injury will affect you for the rest of your life for the next 35 years? How could they have only given you this much money when your attorney asked them to consider this much? And in fact, he even suggested that they could give more. How is that possible? How is this possible? It's possible because the jury is the one to decide collectively, all 6 members of the jury come together to decide how much you are to receive. And if they decide you are to receive a very small amount for your pain and suffering, then that's the answer. And now the same thing for your lost wages, and for your future pain and suffering, and for each element of damage that you've claimed. So why do I share this quick information with you? I share it with you just to give you an understanding of what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet started a lawsuit, but are contemplating, you're thinking about bringing a case, then what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.